Ladies and gentlemen, consider this season 2 of international law. We want to talk about state actors, what we mean by state actors and international law. In international law, the term state actors basically or generally refers to entities that actually have the status of what they call sovereign states and are recognized as such by the international community. However, please understand that international law itself does not typically provide a formal definition of what state actors mean. Instead, it basically relies on the recognition and the practice of states as primary subjects of international law. Those of you who had the privilege of listening to our volume 1 or section 1 or audio 1, you may have comprehended. But the argument here is that the authoritative source for recognition and definition of state actors is often found in customary international law and state practice. So additionally, we could understand that international legal scholars and even textbooks may actually provide interpretations in terms of explanation. But one authoritative document that addresses the criteria for statehood is actually the so-called Montevideo Convention on the Rights and Duties of States of 1933. So while this convention basically does not define state actors explicitly, it lays out the following criteria in terms of statehood, which I would like us to discuss. Number one, it argues in terms of what they call a permanent population. Please understand that. And then number two, it talks about what they call a defined territory. And then number three, it talks about what they call a government capable of exercising effective control over the territory. And then number four, it talks about the capacity to enter into relations with other states. Please understand that. Now, if we are to argue the Montevideo Convention, you please understand that this is a widely accepted codification of customary international law principles related to statehood, and its criteria is, are often referenced when determining whether an entity actually basically qualifies as a state under international law. But it's also important, by the way, it's important to note that the recognition of statehood and state actors is a matter of practice and customary law, and it may actually vary depending on the perspectives of and policies of individual states and international organizations. So as a result, the definition and recognition of state actors are not governed by a single international legal authority, but rather by collective actions and decisions of states in the international community. Yeah, so that is something that you need to comprehend even as you want to understand the depth of it. Now listen, in international law, state actors basically play a fundamental role in shaping the legal framework and conducting what they call international relations. Yeah, and state actors basically refer to what you call sovereign entities recognized as independent states under international law, and these states have certain rights and responsibilities, and they are the primary subject of what they call international law. So I'm going to discuss a few concepts of what state actors under international law, so that you comprehend what we're talking about. Now, if you're to argue aspect number one, which has to do with sovereignty, state actors are basically characterized by their sovereignty, which means that they have the supreme authority and control over their territorial population. Okay, in terms of or government's power, if you like. So the sovereignty it becomes the core principle of international law. It grants states the ability to make decisions within their own borders without interfering, or interference from other states, as it were. Now, issue number two has to do with international legal personality. The argument here is that state actors basically possess international legal personality, which means they have, the capacity to enter into agreements or treaties and even other international legal instruments. In the first audio we talked about section talked about treaties in entirety, but here we are arguing that they can also be parties to international disputes and have access to international courts and even tribunals, the state actors. In terms of concept or issue number three, you want to look at it in terms of rights and obligation. State actors actually have certain rights and obligations under international law, and these may include, for example, the right to self-defense, the right to diplomatic relations, the right to participate in international organizations, and they also have obligations such as respecting the sovereignty of others and refraining from the use of force, for example, in terms of violation of the United Nations Charter, for example, and even adhering to customary international law, or even international law for that fact, and even treaty obligations, as it were. So that becomes another important aspect for you to comprehend. Then another, in terms of issue, would be the aspect of recognition. Now, to be considered a state actor under international law, a state must actually be recognized as such by other states. Okay. Now, recognition can actually be formal or informal, and it's an important aspect of statehood. So generally, a state is recognized when other states establish what they call diplomatic relations and engage in official communication or interaction for that purpose. Yeah. Another important aspect that you may want to comprehend is what they call non-state entities. Yeah. It's important to comprehend that while states are actually the primary actors in international law, other entities such as international organizations, non-government organizations, and even some subnational entities like autonomous regions may also have certain roles and rights in the international legal system. So, however, their legal personality and their rights are often derived from or even limited by recognition and consent of state actors, and that is something that, again, you may want to comprehend and understand in terms of that component. Now, another important aspect you may want to argue when you're talking about state actors is the act of the argument of state responsibility. State actors are actually responsible for their actions under international law. So when a state, for example, violates its international obligation or causes harm to other states or even individuals, it can actually be held accountable through mechanisms like international tribunals or even diplomatic negotiations. And the argument is that these principles of state responsibility basically underscores the importance of adherence to international norms. So that's another important aspect that you may want to comprehend as well. Also important when you're talking about state actors to argue the issue of statehood criteria. Yeah. While the Montevideo Convention of 1933 provides widely acceptable criteria for statehood in terms of permanent population or defined territory or government and capacity perhaps to enter into relations with other states, the recognition of statehood can actually sometimes be a complex and politically sensitive issue. Yeah. And states may actually differ in terms of their willingness to recognize new states, and disputes over statehood can actually be contentious. We've seen that, I think, on a very big perspective in terms of the politics of the diaspora, if you like. So state actors basically are central, as I say, to the functioning of international law. They enjoy sovereignty and have international legal personality and are subject to both rights and obligations. And recognition by that state is a key element for statehood, as I said. And state actors basically play a pivotal role in shaping and adhering to international legal order, as it were. And I'll argue a little bit of more points in terms of concepts that relate to state actors under international law for purposes of driving our point a little bit deeper, if you like. In terms of state succession, for example, you could argue and say that where there is a change in a government or a territory status, the question of state succession may actually arise, and state actors usually must determine whether the successor entity actually remains or retains, for example, or the right and obligation of the predecessor under international law. This can actually be a complex issue, especially in cases where in cases of decolonization, for example, or dissolution of states, or even changes in government, that become another question of debate. But also, state actors can be argued in terms of what they call diplomatic relations. State actors actually engage in diplomatic relations with one another through embassies or consulates, for example, and diplomatic missions in terms of diplomatic immunity, which is granted to diplomats and even diplomatic premises, which is a crucial aspect of these relations, as is governed by the Vienna Convention on diplomatic relations as well. So those are some of the things that you may want to look out when you're arguing state factors. But also, state actors can also be argued in terms of international organization. State actors often cooperate through international organization, such as the United Nations or regional bodies in terms of, for example, the European Union and specialized agencies. Like World Health Organization, for example. So these organizations basically serve as platforms for states to address global issues and even promote what they call international cooperation. that is something you also may want to comprehend when you're talking about state actors. And then in terms of recognition of states, I think I mentioned that, but for purposes of emphasis, I would like to continue urging that the recognition of state is, as I said, a super complex and sometimes politically sensitive matter. So, the argument here is that not all states agree on the recognition of a particular entity as a state. For example, some states may not recognize the sovereignty of other regions, leading to disputes and conflicts. We've seen this playing out in the likes of what? Israel, Palestine, perhaps Ukraine, Russia, those arguments. But if you go to our YouTube, you may find some more discussions on those particular subjects. State immunity is another aspect. State actors generally enjoy immunity from jurisdiction of foreign courts known as sovereign immunity. And this principle is basically based on the idea that one state should not be subject to the legal process of another state without its consent. However, exception exists, particularly in cases of commercial, even tort-related disputes in that context. So you may want to be very careful when you're making that disposition. Then also, you may want to also argue in terms of what they call territorial integrity. International law basically upholds the principle of territorial integrity, which means that the state borders should not be altered by force. Yeah, the principle basically is enshrined in the UN Charter, and violations of what territorial integrity are generally considered breaches of international law, and that is something again you may also want to comprehend. And then still, you could also look at it in terms of the use of force. The use of force by state actors is another regulated aspect by international law. Notably, under the UN Charter, states are actually prohibited from using force against territorial integrity or even political independence of other states, except in cases of self-defense or within the authorization of the UN Security Council. Obviously, these things look beautiful when you're arguing them, but the practicability of it becomes another question of debate, especially when it comes to certain powers that be. Then you could also argue in terms of treaties and agreements. State actors frequently engage or enter into treaties and agreements with each other, in creating what they call binding obligations under international law. And these agreements cover a wide range of issues, from trade and environmental protection to human rights and even arms control. So you may want to comprehend that as well and see it in that perspective. Then state actors can also be looked at in terms of customary international law. Yeah. So basically, in addition to treaty law, which we argued in our section or audio 1 or volume 1 or whatever, state actors are bound by customary international law, which consists of widely accepted practices and norms. So customary law is binding on all states, regardless of whether they are parties to specific treaties. So that is something that you may want to comprehend as well. And then you may want to look at it in terms of what they call enforcement mechanism. International law basically lacks a centralized enforcement authority. So what happens is that states rely on diplomatic negotiations, on sanctions and international courts and tribunals, for example, International Court of Justice and other mechanisms to resolve disputes and even enforce international legal reforms. That is something also very, very important for us to comprehend. Now, please understand that when you're arguing this, you have to argue it in the context of the umbrella of what how state actors can be played out in different arenas in terms of becoming central to the maintenance of international order, or perhaps in terms of resolution of conflicts, or even the promotion of cooperation on a global scale, or in terms of the issues that play out. So those aspects would help you to comprehend and understand. But I would still want to bring out a few other points in terms of considerations, knowing how state actors in the context of international law again, so that we drive our point further, because we labored so much in our first audio or video to talk about the aspects of treaties. Now we want to emphasize state actors as an element, perhaps. But I say sovereignty becomes fundamental because the principle of state sovereignty is a cornerstone in terms of international law. It means that the states have ultimate authority within their territories and are free from external interference in their internal affairs. In terms of respect for sovereignty, it's crucial for maintaining peaceful relations among these states. We emphasize the aspect of recognition as a complex component. Recognition in terms of what is a state as far as statehood, although we have substantive legal basis for that. but it can be contentious because it's sometimes politically insinuated or sensitive to that aspect. And I said recognition may be determined depending on political or historical or strategic factors. And then the aspect of states create and shape international law. State actors are primarily participants in terms of creation and development of international law, and they actually help in negotiating and agreeing upon treaties, for example, and conventions and even agreements, which become binding as legal instruments when ratified. So states actually contribute in terms of the formation of customary international law through their practices and even acceptance as far as norms are concerned. That's another important aspect in terms of that. Then obviously you may want to talk about responsibility and accountability. State actors are usually responsible for their actions under international law. When, for example, a state violates its international obligations or even causes harm to other states or individuals, it can actually be held accountable, as I said, through diplomatic means and international tribunals or dispute resolution mechanisms, and state responsibility basically underscores the importance of adherence to international norms. Those of you who are listening to this particular video or YouTube, it's important for you to still take the entire time to listen to the first section that had to do with treaties, because it's important. There's a connection. Then peaceful settlement. In terms of disputes, state actors also are expected to seek what they call peaceful means to resolve international disputes in terms of use of force that is generally prohibited except in cases of self-defense, or with the mandate of the UN Security Council, or in terms of diplomatic negotiations or mediation, or even arbitration as a preferred method to settling some of these conflicts. You could also argue that state actors can also manifest in terms of international organizations. They often work together through international organizations to address global challenges, and these organizations basically provide platforms for cooperation, for coordination, for the formulation of common policies. I would give and argue that the United Nations perhaps is one of the most prominent international organizations with a broad mandate in terms of promoting peace and security and development in that context as well. Then we could also argue it in terms of what they call non-state actors, in terms of the role they play. Now, while states are actually primary subjects in terms of international law, non-state actors such as international organizations or NGOs or multinational corporations and individuals have also roles and actually influence in terms of international affairs, and they can actually contribute to the development and enforcement of international norms. So that's another thing that you must look out for in terms of comprehending this particular subject. And then another one that is deeply tied in the first YouTube that we did on treaties is the aspect of treaty making powers. State actors have the authority to negotiate and enter into treaties. So treaty making powers may vary from state to state, but typically treaties must be ratified by the state's legislature or executive authority to become legally binding. And that is something you have also to comprehend again when you are talking about state actors. And then obviously you may want to argue in terms of state immunity. State actors are generally enjoy some kind of immunity from jurisdiction of foreign courts. And this principle is known as sovereign immunity, and is based on the idea that one state should not be subject to the legal processes of another state without its consent. However, as I said, there are exceptions to that effect, particularly in cases of commercial or even tort-related disputes, that one can actually be held culpable for some of those aspects. And then you could argue in terms of obligation to prevent harm. States have a duty under international law to prevent actions of their, on their territory that could actually cause harm to other states, or even the international community to that effect. This includes obligations related to counterterrorism, for example, or non-proliferation of weapons of mass, destruction, and human rights, protection as well, in terms of that component. So even as you're arguing that, you may want to comprehend that. So there's a mix of issues when you're doing this. So understanding these components or these points about state actors in international law is essential in terms of comprehending the dynamics of international relations or cooperation and conflict resolution in the global arena. So the point is that state actors, as I said, play a central role in shaping the rules and norms that govern interactions among nations. And that is something that you must comprehend when you are talking about state actors. It's very, very important. I'll emphasize that when you're listening to this, please blend it with the one longer one that had to do with the law on treaties. When you listen to the one on law on treaties, then you can be able to comprehend state actors in terms of international law. Once again, it's a pleasure and an honor to speak to you. This is a dispensation, I think, that has been given by God to be able to share knowledge with our loved ones, but more importantly, to be able to see that we can help a brother or sister become a better entity in their call or their dispensation in terms of what God has ordained on them. My name is Isaac Christopher Lubogo. Please visit our website at lubogo.org. Find most of our materials at suigenerislawapp.com. We have about 50 books now running. We've written groundbreaking areas, and we shall be continuing to relate and to engage with you in terms of the dispensation of what God has given us to share with you. Once again, thank you for your attention, and God bless you. I will take leave and say thank you so much for your attention.